Alex here with part 87 of the My Docket series on child custody and visitation. As my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things to glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. And number two, the nutshell version as of the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. Going straight into the video, we are now going to begin executing on the judgment that the district judge entered. And I think the main document we're going to go over is the recommendation for order that the Discovery Commissioner entered. I wanted to mention in my last video, but I kind of spaced it, I guess. I mentioned that that hearing wasn't recorded, and that's why I couldn't provide you guys with a video. And I should have mentioned one of the legal consequences of that. If you go into one of these hearings and it's not recorded, and you don't bring a court reporter, you better hope something doesn't go wrong, because it's going to be very difficult for you to get any kind of appellate relief without a transcript. Not all hearings are recorded, and I'm not going to spend any more time talking about this in this video because I actually dedicated a video to this topic. So please take a look at the video, Court Reporters. In that video, I explain the danger of assuming that all hearings are recorded and the even bigger danger of not having a court reporter and something bad happening to you in court that you now no longer have a record for you to take up on appeal and challenge. So please watch the video, Court Reporters. It's a big deal. At the time when I went to that hearing, I didn't know that some courtrooms or some of these hearings aren't recorded. I just assumed all of them were. And in my ignorance, had no idea. Now, in hindsight, had I known, it probably still wouldn't have bothered to record it. Unless I knew that I was going to create a YouTube channel 10 years from then it would have been a different situation. But I just didn't have any clue or idea that this is going to be what I was going to be doing 10 years from then. Anyway, I think at this point, the best thing that we can do is actually go ahead and take a look at what the Discovery Commissioner has filed. Here we have the recommendation for order. Just a couple of things I want to mention. There is a difference between an order and a recommendation for order. At least there is in Nevada. In Nevada, recommendations for order are entered by people who help judges but aren't judges in the sense that they can enter orders, I guess. I have a few different videos on these types of roles. One of them is hearing masters and or domestic masters. I can't remember what title the video is under. And then another one is called, I think I have one on Discovery Commissioners. In this particular situation, the Discovery Commissioner is entering this recommendation for an order. So definitely take a look at those orders. The recommendation for an order is just the Discovery Commissioner recommending to the judge that his findings of fact and conclusions of law should become an order. The judge is ultimately the one that decides whether or not it becomes an order. There's typically a local rule, though, at least for sure in Nevada there is, that after a certain amount of time, the recommendation for order, I don't want to say the word automatically, it's presumed that you consent to it becoming an order. If it was automatic, then just by virtue of waiting, it would be treated as an order, but it's not. The district judge enters something called order confirming recommendation or something like that. After the time runs out, they enter it pretty quickly. If you'd like to challenge a recommendation for order, another pitfall is for people to file an appeal to it. You cannot appeal a recommendation for an order. You can only appeal an order, and in fact you can only appeal certain orders, but there is a way to challenge them, and that is typically through what they call an objection to master's recommendation. I am 99% sure that I have a video on that topic. In fact, yeah, I do. So if you want to learn how objections to master's recommendations work, just check out that video and I explain more. There is a part of that process that ties into the appeal process, but it doesn't start there as it would with an ordinary judge. Here we have the standard introductory paragraph. The Discovery Commissioner is indicating that on June 25th, 2012, the court entered an order requiring my ex to appear before him for an examination. The examination was scheduled August 16th, 2012. At that time, she appeared and underwent examination by me in connection with a judgment that I had obtained against her. Let's see. Next paragraph. I am asserting that I'm attempting to garnish her wages and that her employer will not comply with this enforcement obligation unless the petitioner provides the employer with a social security number. This is the only basis offered. Okay, so I want to mention this. I've worked in collections, 2 different companies, several years. Never have I ever heard of an employer ever accepting a writ of garnishment without a social security number included. So the fact that this commissioner finds out that the VA hospital has a sort of roundabout way of doing it was, number one, a complete shock to me. Had I known that, I would not have argued that in court. I just want people to know that. And number two, I think that approach was really what showed me that not all judges are like my family judge. This judge was solution oriented. He wasn't just trying to find a reason to deny my request, to nitpick at what I was asking for, to berate me, to belittle me. He was like, we have a problem, let's solve the problem. And he solved the problem in the way that I think to him made both of us happy. And in my opinion, it made me perfectly happy because all I needed to do was make sure that I could execute on the judgment. I didn't need to have the social security number if there was a way to get around needing to have that to execute on the judgment. The way that my ex was able to persuade him to consider that was annoying. And the fact that he was duped into believing her is even more annoying. But he did later on find out that I won the Supreme Court case. And there's another time that I subjected her to a debtor's examination. And as soon as he found out that her fictitious address was canceled and all of that, he, of course, pretty much didn't give her any sort of leeway at all in this whole vein of, I'm a victim, please help me, he's dangerous. But we'll find that further down in the order. I actually already brought this up in one of the videos where I cover the Supreme Court writ of mandamus that I filed against the Secretary of State. I'm not sure if you guys recall, but at the very end of that thread, and it's not completely over yet because we're still waiting on an order, but at the very end of that thread, I actually filed something in the Supreme Court to let them know how my ex and her attorney were able to dupe people like the Discovery Commissioner by exploiting the 2 inconsistencies in the statutes that they've been exploiting for years. So anyway, there's a lot behind all of these shenanigans, but that's what abusers do. That's what attorneys do. Well, at least attorneys who represent them. It's win at all costs. They find a way to win. They don't care if it's right or wrong, what the truth is. None of that matters. It's just, to them, victory is everything. And in fact, if you want, you can take a look at my video, Win at All Costs. I go a little bit more into that. Next paragraph. Without question, federal law provides for garnishment of the pay of federal employees, which is good. To that end, federal regulations have promulgated to assist judgment creditors who seek to enforce their judgment against federal employees who are judgment debtors. So what he's doing is he's bringing up some of these regulations, and I just think it's so awesome that he went and looked these all up. Really, it just felt like the family judge just didn't care to rely on law unless he absolutely had to. And the Discovery Commissioner, he's just on point. He goes, he does the research. He doesn't just sort of say, these are the things you're gonna have to do because I said so. He says, these are the things you're gonna have to do. Here's all my citations to the law. That is what I expected a judge would do. And even now, as I look at this, it's a whole nother class of judge. It's ironic because he's not even a district judge. He's a commissioner. He doesn't even have the power to enter an order. He can only enter recommendations for order. Yet the first impression that I got from this person was top notch, 10 out of 10, way above and beyond the district judge. And in fact, I never forgot this guy. Even to this day, I remember his name, Wes Ayres. I think that's how you say it, Ayres. It's either Ayres or Ayres, one of the two. But I've never forgotten this guy. And let's continue on. Next assertion is that federal regulations pertaining to garnishment provide, and then he goes through these things that I need to provide. Parties seeking garnishment should provide as many of the following pieces of information concerning the employee as possible. And here's the employment number, or social security number. So I think the way I get around it is with the employment number. If the information submitted is not sufficient to identify the legal process is returned directly to the court with an explanation of the deficiency. However, if it If the designated agent can do so prior to the applicable deadlines for compliance, the agent should try to inform the person who caused the legal process to be served that it will not be honored unless adequate identifying information is provided or supplied. Next paragraph is, I informed the court that an employee with the Department of Interior told me that garnishment actions would not be taken without the Federal Employees Obligers SSN. But the VA Medical Center in Reno is not a facility within the Interior Department. So statements by an employee within the department do not establish the requirements of the Reno VA Medical Center for taking garnishment actions. The fact that one agency imposes a requirement doesn't mean that all federal agencies will impose the same requirement. So if you doing my research on what the VA hospital came under is what led me to the Department of Interior. It was either that, or it was what my ex indicated, or it was what was printed on her paychecks. One of those things led me to the Department of Interior. He is stating that he found some internal regulations specific to the VA Medical Center that states otherwise. The request for the SSN is problematic based on the difficult relationship between the parties. And then here he goes into the temporary order, which we went over in the earlier parts of the My Docket series. And then he goes ahead and mentions the confidential address program. And then he cites the same exact statute that I was concerned would be cited. So based on this law and the fact that she has a confidential address, he is automatically assuming that specific evidence showing that DV has occurred or that she is a victim. He's been duped. And there's nothing that you can do about this except for do what I did, I guess, which was to file something in the Supreme Court of Nevada. And unfortunately, at the time that he entered this order, the Supreme Court of Nevada had not rendered its decision. But they are within about a year of doing so, because we're looking at August 2012 here, and it's somewhere around June or April of 2013 that the Supreme Court of Nevada finally publishes a decision taking care of all of this nonsense. But for now, that's the rule he's going to rely upon, and he is going to assume she's a victim of DV when she actually isn't. And it's a disappointing thing to see, but it doesn't matter because I ended up not needing the social security number anyway, and he put forth a better solution, one that didn't require a social security number, and I was ultimately able to garnish your wages. So in the end, everything worked out, but it was a very frustrating piece of paper for me to go through, and luckily I was able to take this piece of paper and show it to the Supreme Court as proof that this was a problem, because look, here's the two confusing statutes and look what my ex is doing. Certificate of service, and that's just indicating that this document was mailed to both myself and my ex. Here we have the affidavit of, why is this here? Oh, I'm probably going to be using this later. I filed an affidavit from my son's kindergarten teacher, and it was just sort of a preparatory thing. I didn't have it sort of cited yet, but I did plan to eventually cite this affidavit at some point. And anyway, because it was filed at this point in time, I'm going to need to, actually go through it. And this is the kindergarten teacher, and she is stating she's over the age of 18. She's never been convicted of a felony. She's married and has lived in Nevada for 6 months. She is utterly dismayed to have to involve herself in the matter, as she has a strict policy of putting her students' interests first and staying out of parental disputes. However, the severity of the issues and the impact she believes these crucial initial years will have on our son compel her to come forward. She has been a kindergarten teacher for 10 years. She served in Washoe County Public School for 5 of those years, with the remainder being served at Coral Academy of Science. She was our son's kindergarten teacher for 2011 to 2012 year, and she's been in contact with both of us, and she's been notified of the order of the courts for our son to attend the school. She has not known me, our son, or my ex prior to the beginning of the 2011-2012 school year, nor is she presently friends with or related to any of us. Throughout the early weeks of August, our son's 2011 kindergarten year, she became concerned with my ex's conduct. In particular, the volunteering of information regarding matters of the custody dispute between her and me that were not relevant to our son's education, making disparaging remarks about me, and disregarding or otherwise marginalizing our son's behavioral issues when she brought them to her attention. In the later weeks of the 2011 kindergarten year, the situation worsened so much that our son's behavior was becoming far too disruptive, not according to Coral Academy of Science standards, but according to the general standards of the Washoe County School District. She's also stating that she began to notice there were night and day differences regarding how our son behaved when my ex dropped him off versus how he behaved when I dropped him off. Eventually, she appeared to have grown resentful and would discuss our son's behavioral issues with her, and any further communications that she had with her were received with incrementally increasing contempt. On September 9th, 2011, she held a parent meeting with me and my ex and discussed our son's best interest. She had hoped that because he was 4 years old, he could benefit from an additional year of preschool. Specifically, we agreed upon the following determinations, and this is the stuff about how he's just going to come back next year. She encouraged the decision with great regret because our son was absolutely a very intelligent child who would benefit greatly from an education at Coral Academy. The next assertion is that once he was no longer her student, she reported to me the above-mentioned conduct of my ex so that I would be aware of the underlying issues and hopefully be able to address them with my ex. Nope. Unfortunately, at the start of the next year, so we're going back, my ex's conduct became far more contemptuous, specifically by marginalizing her discussion with marginalizing the discussion regarding our son having struck another boy in the face and telling her that she would deliberately disobey the school's dress code when she advised her that our son's shoes and pants were not appropriate. Oh my gosh, I forgot to tell you guys about this. She would send him to school in clothes that didn't fit. What was weird is that she would do it on purpose. This actually does end up coming up. It gets brought up at a hearing, so you're going to get to see this at a hearing with my ex testifying on it in front of the judge. So I don't want to go too much into it now because you're going to get to go through all of it in its full glory. But it seemed to me that she was doing this to sort of get revenge on everyone. It was this attitude that she had that was like, since none of you will let me do what I want, I'm going to hurt this kid. It was like a hostage-taking attitude. It was, Sam Vaknin explains it perfectly. He states it's like she was trying to settle these open scores with the world. Like everyone, the teacher, me, the judge, her lawyer, him. She had to get even. And that's just the way she did it. It was a disturbing, it was a sick thing. But anyway, I'm going to stop talking about it now because it's going to come up at the hearing and you're going to get to see it completely, all the way through. Next assertion is that Coral Academy of Science held its annual Parents' Day. Our son appeared with me. My ex failed to appear. At that point, the teacher discussed with me the situation regarding my ex and informed me that it was beginning to appear that my ex was intentionally trying to sabotage our child's education. She was. There's two things that I'm going to say. I'm not going to go into detail here because it just makes me angry. But number one, yes, a parent can, on purpose, ruin their own child's education. And number two, there are judges out there who don't think this is a possibility. And quite frankly, they should be fired. There are parents who will, on purpose, deliberately take actions to ruin their child's life. If a judge does not think that this is a possibility, they need to be fired. I'm not saying it's common. I'm not saying it's most parents. It probably is either very uncommon or rare, but it does occur. It's not always neglect. There's parents who just don't care, and their children suffer because their mom or dad just does not care. And then there are parents who do care, and they specifically go through a list of actions to intentionally cause the destruction of their child's education. And I just want to tell my viewers right now that that is exactly what happened. My ex, on purpose, deliberately, took a series of actions to ruin his education. And I just want to make it clear to my viewers that this isn't something that happened through neglect. This isn't something that happened on accident. This isn't something that happened because she meant to do one thing and she accidentally did something else. No. She had a mission. That mission was to ruin his education, and she executed a plan in order to try and satisfy that mission objective. And I really need people to sort of let that sink in, because this is something that does happen. It's rare or it's uncommon, one of the two, but it does happen. It is possible. And in my opinion, it's probably firmly rooted in mental health issues. But I want to make it perfectly clear for my viewers that this is a possibility, that this does happen in high conflict child custody cases. And then, of course, there are judges who just don't believe it's possible. and they won't even look into it because they don't care. But we're going to move on to the next paragraph here, which is that it is only as a last resort that I come forward, and this is the kindergarten teacher, with this declaration, and only because it appears that my ex has indicated the pattern of conduct and acts of bad faith will perpetuate and ultimately result in the demise of our son's education. Okay, we have the declaration in lieu, which states under penalty of perjury that the foregoing is true and correct. And if you want to learn more about what this declaration means, because it is a very specific list of words that has to be stated verbatim for it to work, please watch my video, Affidavits and Declarations. I explain how it works in Nevada. It's because of a Nevada statute that I can do this. Normally, you have to get a notary, and they have to put their little stamp and seal and sign in their little book and all that. But if you watch that video, I explain how you can get around having to use a notary and how you can just make sure that you use this specific language. Affirmation, which indicates this affidavit doesn't contain a social security number. And then the Rule 5 certificate of service, which indicates that I personally served this affidavit upon my ex's attorney. Next document, memorandum of costs. I've gone over these once before, and it's basically a bill. These are the costs that I intend to tax against my ex. And I don't know, actually I do have a video on this topic, and the video is called Costs and Attorney Fees, or it might be called Attorney Fees and Costs. Anyway, in that video I explain how the memorandum of costs works. Oh wait, this is a memorandum of accrued costs. This is very slightly different. Everything that I said applies with one exception. With the memorandum of accrued costs, you don't have to ask the court's permission to get those costs reduced to a judgment. Instead, you are allowed to, by law, bill your ex within the execution, the writ of execution, immediately. So they're even more convenient because you don't have to get the judge to give his stamp of approval. You can just bill your ex without even asking anyone. Now, there is a way for your opponent to challenge this, but the onus is on them to do it. Like I said, you don't have to do anything. You don't have to ask for approval. If they have a problem with what you're doing, they have to do something about it. They have to go to the court and ask for the court to take a look at what's going on. So accrued costs are one of those things that are, it's one of the best things about executing on your opponent. If you're going to have to incur costs for executing on a judgment, any of those costs that you execute are accrued costs, and you can just lump them all into the bill, and you can just take that out of their assets as well. And that's what's going to happen here. So we've got two different bundles of accrued costs that I'm going to bill against my ex. And the first one is the issuance fee for the writ of execution on my ex's bank account. The second one is the service fee by the sheriff, and then the third one is the garnishee fee. Both of these garnishees get a $5 check, and the reason why is because the law says so. In the law, the Nevada Revised Statutes, it says as a fee for their service, for their attention, or whatever. I don't know why they get $5. Anyway, I'm going to go ahead and tax those $5 fees against my ex. And then both times you can see that both of these garnishees were served by the sheriff. I just want to mention to my viewers, typically you can serve somebody with anyone that's not you over the age of 18. And I'm talking about Rule 4 service, and that's just the general sort of service of the initial complaint and summons. That's typically what people see happen in the movie Pineapple Express. Anyway, this is a different situation here. This is service of execution, and it's different. You can't choose whoever you want to have documents like this served. It has to be, at least according to Nevada law, it has to be either a constable or the sheriff. Nobody else is allowed to serve these. Not you, not even a process server, not a licensed process server. Nobody. It has to be the sheriff or the constable. And that's because if you think about it, this is a part of the court process that's not even really being supervised by the judge anymore. Once you enter this part of the process, you, the judgment creditor, are for the most part just doing whatever you want to try and collect these monies. And so one of the things that Nevada requires is that these documents are served on these third parties, these people who aren't even a part of your lawsuit, like the VA hospital, Bank of America. These people haven't been sued by me. These people haven't been noticed about a lawsuit. These people aren't involved in the lawsuit. They don't know what's going on. And so this sensitive part of the process with these third parties who aren't involved in the lawsuit is protected by various different means. And one of them is that documents like this are to be served upon them only by the sheriff or the constable. I don't know how it works in other states. I don't know if other entities can serve in other states, but in Nevada, no, it has to be them. And then I think I mentioned the issuance fee. That's a fee that you pay to the clerk of the court when they issue the writ of execution itself. It's a $10 fee. I did it twice, so $20. Moving on. Rule 5 certificate of service indicating that I served this memorandum of accrued costs upon my ex's attorney. Here we go into the minutes. Judgment creditor Alex Falcone was present and not being represented by counsel. Judgment debtor Monica Farrar was present, not being represented by counsel. My ex, called by me, was sworn and testified. Notice here that it says that she was sworn and testified, but I was not. Discussion ensued regarding whether she should have to provide her social security number. The commissioner determined that the matter would be taken under advisement. Notice of intent to modify custody. Okay, so this is consistent with that earlier affidavit. I'm basically placing my ex on notice that if she continues to act in bad faith regarding my son's education, that I would take, as a last resort, I would file a motion to modify child custody. This is a pointless document. I shouldn't have filed it. Why bother including something in the docket that has no effect on the lawsuit at all? If I wanted to send something like this to my ex, I could have done it by email, and I would have probably needed to send it to her attorney, not to her. So, and I think I did send this to her attorney. Let's take a look. Yep, Rule 5 certificate of service, and I sent it to her lawyer. So yeah, I mean, guys, it might feel good to do something like this, but all you do is clutter the docket and annoy everybody. The judges aren't going to look at it. It's just another piece of paper in the millions of pieces of paper that they don't have time to look at. Extra stuff like that, you can send it out, but there's no reason to file it. Don't file extra stuff. And here we have the first writ of execution. I know we've got a few more of these coming. It looks like in this video we're going to just go over 2 writs of execution. So here's the first writ of execution. And if you guys don't know, I don't want to go over all the details because I have a video dedicated to this topic. If you want to learn more about this process, please watch the video Execution and Asset Seizure. I'm still going to go through the document to the best of my ability, but I feel like you guys aren't going to really get a full 3-dimensional picture of what this process is and how it works unless you watch the video Execution and Asset Seizure. So the writ of execution has to be very precisely filled out. It has to be perfect. The clerks of the court take verification of a writ of execution very seriously because they know you're about to take somebody's money from them forcibly. It's a very serious thing. It cannot be off even by 1 penny. Nothing can be wrong. The dates and times have to be perfect. The names have to be perfect. Everything has to be perfect in the writ of execution or they will reject it. So here I have to refer to the order. This is the order that I'm referring to. And this is the judgment that the court entered. It's in favor of me, it's against my ex, and then I have to go through the amounts that are owed. The principal, the attorney fees, the interest, the costs, and then the total judgment is entered. And this needs to match. They will check this. And this is one of the reasons why the family judge was wrong when he said that my request for a judgment was superfluous. Think about it. He said, all I need to use is the child support order. But the child support order doesn't say how much I'm owed. It says how much my ex is supposed to pay per month. How is the clerk of the court supposed to know if she's kept up on her child support? They're not going to have any clue. So what they need is a judge to say, this is the exact dollar amount that is owed to him. So that's what the clerks do. They look back at the order and they look. They don't look for just some general language of money being owed. They look for something that says, this person owes this person this amount of dollars and cents, period. That's what the clerk wants. If you don't have that available, they will not issue a writ of execution. Scrolling down, it goes into the second portion, which are the amounts that are accrued. These are the amounts that I can just come up with on my own. Do not abuse this process because I am very, very sure that there is some kind of criminal or civil penalty for people who abuse this process. This process is not supervised by the courts. You could put almost anything in here. I don't think you could do that with the accrued interest, but you could put in almost anything in these accrued costs, and the clerks, they'll just take your word for it. So be very careful about messing around with this. I honestly have never done that before, and I just shudder to think what would happen for somebody to do something like that on their ex and get reported for it. So if you have accrued costs, report the accrued costs that are specifically connected to executing on the judgment. Nothing else is going to count as an accrued cost. It has to be associated with collecting on the judgment, and it has to fall within the boundaries of what a cost is. And then for the accrued interest, make sure you do your interest per day. You have to actually do the math. You have to break down the principal amount. You have to break down how much interest you get per day based on the principal. Typically, you want to take all payments from the debtor and apply them towards principal just to be safe. That's what I would do. I'm sure you'll probably be okay if you apply their payments towards interest first, but I'm not 100% sure about that. And to just err on the side of caution, I just always apply my ex's payments towards principal first, just to be safe. The fee for the writ, which is $10, which is here, and then we've got $38 in accrued costs. And that's all of these summed together. So we got the interest, the fees, etc. Here's the credit for the payments that my ex has made. I give her credit for that. And when you start to seize monies from your opponent, that this number will go up, and it needs to match exactly what the sheriff has seized, or the sheriff or the constable, whoever's handling your execution. And by the way, now that I mentioned that, just so you guys know, when you serve these writs, the company that you serve is not going to give you the money directly. If it's Bank of America, if it's their employer, whoever it is that you've served with the writ of execution will provide payments directly to the sheriff or the constable if they're the ones that are doing it. Those payments are then held by the sheriff or the constable for a while. I think it's like 30 days. And that allows for the judgment debtor to raise alarm bells if something's going on. If somebody's pulling a fast one, if somebody's... There's a gap of time that allows the judgment debtor to try and freeze that money and get it back in case you're doing something that you shouldn't be doing, or in case they just want to file an affidavit claiming exemption and claim that those monies are exempt from execution, because they can do that too, and I've seen that done before. Anyway, we get to the total here, $94.65, and then we get to the rest is just math. You guys can take a look at it. This is how I break down the interest and the interest per day and all that. Next here we have the affidavit of service from the deputy, the authorized agent, which is going to be the deputy. I wonder what his name is. Here he is, Robert Clark. So this is the guy that works for the sheriff's office. And here's who he served. Bank of America, and this is the name of the person that he served at Bank of America. And this person now, this Samantha Cauldron, she's going to give the document to the legal department. The legal department is going to look on my ex's bank account, and then they are going to take the money out of her bank account. There's one more thing that's missing, actually two more things that are missing. One of them is the writ of garnishment, and then the other one is the instructions. And those documents I talk about in the video, execution and asset seizure, those documents instruct the garnishee as to what they're supposed to do. And I think there's also something called the interrogatories that the garnishee has to fill out. It's a list of questions that they answer that has to do with the assets that are being seized and all that stuff. You can watch the video execution and asset seizure if you want to learn more about that. Here we have another execution. I'm going to go through this one a lot more quickly. And it's the same exact thing, also served on Bank of America. I wonder why. There was probably something that was different or something that was wrong. I don't know, something like that. Something must have gone wrong. There is another entity that I serve, and that's the VA hospital, but I guess that is going to come up in the next video. So for now, going into the aftermath, I filed 1, 2, 3, 4, 5 documents, but they were not all free filings. Most of them were free filings, but those 2 writs of execution cost $20, and then there is going to be some service of process costs that are going to be connected to the $20. So rather than give you the exact dollar amount, I'm going to do the math afterwards. You'll see it slide up next to me. It probably already has, and that's the number. My ex has not filed any documents, so she's incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably not even cared to look at either of the writs of execution, so I'm not even going to count those. The notice of intent to modify custody, I doubt she cares. And it's not that she's an attorney. She's going to care about what she needs to respond to. It's a job for her. So if she needs to file something, she's going to care. But if she sees me file a document that it's just there for her, she's probably not even going to read it. She probably doesn't care. Maybe she'll forward it to my ex in an email and say, here's something Alex filed. That's it. Something like that might happen. So we're looking at maybe 2 minutes there. The minutes were something that the attorney would have read, but they were very short. So 3 minutes. Let's round that out to 5 minutes. Memorandum of costs. She probably just forwarded it to my ex. I doubt she cared. 5 minutes just in case. So that's going to come to 10 minutes. Affidavit of the kindergarten teacher. She might have read that more thoroughly. In fact, there might have been a discussion there between the attorney and my ex. Not sure, but there might have been one. And so I'm going to go ahead and say 10 minutes. I think that's fair, which is going to take us to 20 minutes. And then we got the report and recommendation for order. I mean, it's an order that hurts my ex, but what's the attorney going to do about it? She owes the child support. So I think 10 minutes, again, to be safe. That's going to bring us to 30 minutes. In attorney fees at the rate of $250 an hour, that's going to come to specifically $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.